Good morning to everyone.
Autoridades, personas expertas.
Welcome to the experts, authorities, public, the audience, and specialists in justice. Welcome to this conference, the second regional conference of the International Association of Women's Judges in Europe, North Africa, and the Middle East. I'm a judge. I work in Valencia. I'm a specialist in gender violence, and it is an honor for me to participate in this conference, participating and offering my small part. I would like to say, to give you a warm welcome. For the people in this room, I'm sure we are all very pleased to see that we have people from all over the world. But our shared perspective is the gender perspective, an analysis and the development of this gender perspective. The fact that we all come from so many different places makes me think that we have a great starting point. The fact that the gender perspective is a universal concept. And it goes beyond borders or professional structures. It goes beyond these concepts. It's more than just theory. It's not individual theory. It's a plural concept. This is an element or something which affects the whole of society and, of course, justice. We're going to talk a lot about gender perspective in this conference with experts on the subject that we will hear from, and I'm sure they will reveal new things to us. Of course, you are going to be given the chance to participate, and that will make this conference much more beneficial and will provide us with more instruments for enforcing the law in the future. From AMJE, we would like to begin this conference with a universal act. What is more universal than music? So we have a young musician with us. She's just 25. She is called Jimena Andion Garcia. She plays the cello, obviously. She's from Galicia in Spain. She studied in Galicia, but also she has been abroad, Poland, Istanbul, and she has played with the Lyrical Association in Galicia, with the Philharmonic Orchestra of Pontevedra, and she participates in many organizations. So I think there's no better way than to start than to listen to her musical performance. It's a piece by Bach. And, well, as the day goes on, today and tomorrow we will hear from her again. Thank you.
Muchísimas gracias.
Thank you very much for the opportunity to attend this conference. I would like to say that this conference is the result of constant interest amongst women judges to make sure that justice is impartial and gives equal treatment. I would like to say thank you to everybody in the Women's Institute who have organized this conference. We know what that means and involves. It's like domestic work. It's invisible and systematic, but everybody benefits from it because it generates great quality of life. So I would like to thank the director of the Institute, the Programs Office, and the Communications Cabinet, of course. I would like to thank Gloria Poyatos for being the way she is. She is always intervening in the media whenever there is a sentence which is not impartial. It's true that in justice we hear a lot about the gender perspective. I think that we are at a conference that should be a reference point when it comes to referring to the conclusions of important interventions that we will see during this conference. We have international speakers and national speakers, and I have to tell you that they have paid their own accommodation and everything they could in order to join us. So I would like to a round of applause for everybody who has made this event possible.
Me siento absolutamente honrada.
I feel really honored to be here. You can see that we all are surrounded by people with a lot to say who represent institutions which work to make sure that justice is carried out impartially. I think that it's necessary for us to talk about impartiality rather than the gender perspective, because the gender perspective seems to include a way of interpreting justice, and the principle of impartiality talks about a justice system which is all about regulating rights regardless of sex, race, age, or personal circumstances of each individual who is looking to have their rights guaranteed within a democratic country. In our country, we have a shameful lack of women in positions of responsibility in the judiciary system, in the positions where important decisions are taken. Over 40 years of the Constitutional Court, the only female, we've only had one female president. She was a wonderful lawyer. She was absolutely 100% impartial, and she took positive measures in employment, education, because women, we are the majority of the population in all countries. We don't need to ask for any favors. We should understand that the person interpreting and enforcing impartiality must be themselves impartial. But we only have 12 female magistrates in the higher level. And in the Constitutional Court right now, we have a woman, María Luisa Balaver. So if we want to comply with our constitutions, justice is the main body which guarantees that. And the Constitution tells us that we should be living in a country which is free of violence and in which my declaration should never be questioned because of my gender and the fact that I represent women. When we say that without impartiality, without equality, there is no democracy, we are not simply, using a slogan here, but rather a demand that we make so that women can really decide. In the enforcement of laws, we have to take into account the subordination of women in many countries, and this has been verified by statistics. We have to investigate cases in which equal treatment is not ensured, where there is no guarantee that everybody will be considered a credible witness, and that the role of daughter, wife, or mother should not be questioned. and should not influence in the protection of my rights. As Clara Campoamor said, equality is learned, and it can only be learned by exercising it. It's an exercise of willpower. Here, we must criticize decisions which have subverted or breached these rights. Thank you very much. Thank you. My name is Esmeralda Rasillo. I am the Director General for Relations with the Justice Administration. My first few words must be to thank all of the organizers. I know that to organize a conference of this kind requires a collective effort, but that collective effort is something that has normally characterized women. We always contribute rather than subtracting, let's say. It's based on dialogue, away from confrontation and insults. Since there's not much time, I'm just going to give a few indications. I would just like to say that from the Ministry of Justice over the last 10 months, during which we have been in power, the Minister of Justice gave priority to the fight for equality. This was one of the main pillars. And during a legislative period, which has been highly complicated, those who have come from other countries, I would like to tell you that the party in power only had 84 MPs, so it was very difficult to pass laws which were really necessary. And why were they necessary? Well, first of all, I think we have to highlight in this context the value of justice. Justice gives social peace. Justice gives economic wealth. And it is there for all citizens. These citizens, well, over half of them are women. And this is an unstoppable phenomenon, because it is not related to ideology or governments. It's civil society. It's coming from the grassroots. That's where this phenomenon is starting, and it's unstoppable around the entire world. In Spain, I think we can proudly say that we are one of the first countries to highlight this battle for equality, which is all about improving the coexistence of all citizens. From the Ministry of Justice and in terms of legislation, what have we done? Well, we have brought out a royal decree, law in August, in consensus with other ministries, which established very important measures, taking into account children who are also victims of gender-based violence. I shan't go into details, but it is a very important law. When it comes to ensuring that judges and prosecutors have real solid training in equality issues, the organic law of the judiciary power has been modified. It was modified in December of last year with the introduction in the public exams of training in equality. In fact, in the Ministry of Justice, we have promoted the modification of the subject matter for public exams, and this has been approved by the selection committee. So in other words, in the next public exams for public employment, the subjects include equality issues. And in the Secretariat for Equality, well, if we talk about the number of female judges, I come from the prosecutors' branch, let's say, and that's what I studied. In Spain, we have 2,500 prosecutors. 72% of us are women, but only 13% hold the highest positions within the prosecutor's office. And this is not an issue related to age. No, I studied at a time when, well, many people that came after me have high up positions. The problem is conceptual, and this is important. The judges and the prosecutors need to reflect upon how we are seen in society, how women judges and prosecutors are seen, and how we are seen as collateral victims as well of gender violence and domestic violence. So to finish, I would just like to provide a bit of context by saying that Spain has a great burden with gender-based violence. We're talking about almost 1,000 women who have died since 2003. This year, 17 women have already died. I must say that within the context of Spain, there is not a high criminality rate in general. However, the homicide rates are increased greatly by this terrible gender-based violence that we suffer. Another aspect that we have dealt with, but due to the fact that we are coming up for general elections, we haven't been able to carry this through. This is protection of minors, the violence against children, any kind of violence against children, above all against young girls who are migrants. They are particularly vulnerable. There's a lot to be done, and the ideas that you are going to talk about today will be studied and analysed, because I insist civil society is what is really pushing us on to respond to that call. Thank you very much.
Good morning. Sabah al-Heidi. Buenos días. Quiero darles la bienvenida, señor.
I would like to welcome you, ladies and gentlemen, authorities, representatives. On behalf of the Women's Judges Association in Spain, I welcome you to this conference. This is the second regional conference of the International Association of Women Judges for Europe, Middle East and North Africa. Before anything else, I would just like to thank the Women's Institute for their great work in organising this, and I would highlight the human team behind this. We can't see them right now, but they have been led by the Subdirector General for Programmes. And I would also like to thank, with great emotion, my colleagues from AMJE, my sisters. I would like to thank them for the time, effort, perseverance, all of their efforts over the last months to prepare this meeting. This was just a dream in the past and has become reality. And I would like to, again, insist on thanking Doración Jiménez. In exceptional circumstances, she has joined us here today. I would also like to thank Lucia Vilés, who has not been able to come, but we send our support to her, and I am sure that she returns them from where she is. Thanks also, important, thanks to the AECID, the Spanish International Cooperation Agency, because this has made it possible for us to have 33 judges here from Syria, Libya, the Yemen, Algeria, Tunisia, Morocco. Fellow judges who are going to talk to us about what is happening with women and girls in their countries and how justice can be a transformational tool. Also thanks to the Council General of the Judicial Power, thanks to their Equality Committee and their training service, because they have included this conference in their training program, ongoing training program. And here we have 50 judges from the Spanish judiciary. So we welcome them also, and we hope to meet your expectations in this conference. Thanks also to the IAWJ, represented by Vanessa Ruiz, who unfortunately has not been able to join us, but we thank them for allowing us and trusting in us to organize this important event, which for the first time is being held in Spain, in this wonderful city of Madrid. And Thanks, of course, to the other pillar upholding this conference, our 48 collaborators in 6 bureaus coming from 21 different countries. In a voluntary, altruistic way, they are going to share with us their great knowledge and experience. But above all of you, the people in the room. Just a few weeks after announcing this event, we've filled this room, people coming, mainly judges, male and female, from 35 different countries around the world. Some very exotic, far-off countries, such as Sri Lanka, the Czech Republic, Dominican Republic, Argentinian group, our friends from the Philippines. Austria, Belgium, Cameroon, Canada. Cameroon, a great effort, lots of problems to be able to join us here. She's here with us. Senegal and many other countries around the world. But I'm going to highlight one of all of these. This is a country that is close to us, Portugal. I would like to talk about Portugal, because today is the 45th anniversary of the revolution in Portugal. This revolution changed Portugal forever. The Carnation Revolution. 45 years ago in Lisbon, a woman, Celeste Carreiro, shared out carnations amongst the soldiers. What happens is that popular history and this attempt to wipe out half of the population means that we do not remember that as we should. So here I think it's time to remember Celeste Carreiro and what she did 45 years ago. I would just like to wish you all a wonderful conference. I hope you learn a lot. This is a different conference. It's global, international, absolutely essential and positive, as well as being critical. We are going to carry out a difficult task with great responsibility, which is all about delivering justice. That involves recognition, redistribution, and representation. Recognition of the rights for people who are denied them. Redistribution in an equal way with a gender perspective, and representation of a complete approach to society formed by men and women. I would just like to finish with one phrase which defines the essence of this conference. This is a phrase said by a member of the IAWJ, but she is not just any old member. She is an icon in an international level. She is in the Supreme Court in the United States. Ruth Bader Ginsburg. She said something as great and as simple as fight for what you believe for and what matters to you, but do it in such a way that other people join you. Thank you. I would like to welcome Pilar Sepúlveda García de la Torre from the Council General of the Judicial Power. First of all, I would like to thank the IAWJ and Gloria Poyatos for that wonderful, emotional introduction. I really would like to thank you for all of your efforts in ensuring this conference took place, and of course all of the speakers for their solidarity and generosity. I would also like to thank all of the people who have come to attend the meeting. In the Council General of the Judicial Power, in the Equality Commission, and everybody, it's a real challenge to fight and achieve real equality in the work of judges. Right now, we have over 5,400 judges, 5,470, and we have 2,967 women. This is quite a considerable figure if we bear in mind that in Spain, until 1966, it was forbidden for women to be judges. And the first woman who became a judge in Spain was in 1976. So the numbers have increased very rapidly, so much so that if we look at the ages, we can see that between 31 and 40, women judges represent 67.1%, whereas male are 32%, 32.9%. If we look at by age, we can see that between 61 and 70, women represent 26.9%, and men 73.1%. As Esmeralda said, this is not a matter of age, because we have enough women. However, we are not in power. In 7 of the regions of Spain, in 15, we have a majority of female judges. However, there is only one president of the superior courts. So of these 17 regions, in 15 we have a majority of women, but there is only one president. If we talk about 52 courts, only 7 of these provincial courts are chaired by women. We've made progress. In 2015, we only had 9 judges in the Supreme Court. Now we have 15. But we have 68 male judges. Therefore, this is disproportionate. So what's happening? Do we have this glass ceiling? In the training commission, we have studied the fact that we have a sticky floor as well. The fact that women take charge of bringing up children and looking after elderly people. We do not have sufficient resources to be able to look after our elderly parents. So when we're young, women look after their children, and when we're older, we look after our parents. So this creates a sticky floor, and this means that we can't even attempt to go through that glass ceiling. We just can't even take off, let's say. In the council, we have promoted training, not just training, as Esmeralda mentioned, in preparing for public exams, but training in the judiciary school, and also everyday training, in ongoing training for our judges, not just for equality and on violence, but also in a cross-cutting way. We have included these issues in many courses, because often in gender-based courses, only people specifically interested attended those courses. So we've tried to include gender in all courses. We call upon judges to interpret laws, to carry out tests and analysis, to bring together the consequences and causes. However, we once again find very sad cases. I could quote one because Ángela González Carreño, who was convicted. We have tens of reports from women saying that the father had threatened to kill the daughter. But what happened in those cases? Well, it was argued that the woman just wanted to take the child away from the parent, from the father. We have famous cases, and we all come across these cases in the courts. We have gender stereotypes which prevent justice being delivered. And, of course, justice does not always match reality. We have to bear in mind that in all cases where a woman is involved, we have to look at the underlying causes, education, and everything in their broader context. I think that the typical image of justice, the idea of a woman with her eyes covered, we have to get rid of that. Justice has to have a clear vision of the reality of women asking for justice. So I would once again congratulate you. I think the program is wonderful. I will try to come to as many sessions as I can and participate, because I think this is a real step forward towards true equality.
A continuación.
And now, it's time for my colleague, sister. She's a co-director of the region of Europe, North Africa and Middle East of the IAWJ, Saïda Chebili. In addition, she is the president of the Tunisian Association of Women Judges. She promotes women in these places, for instance, promoting the creation of the Association of Women Judges in Yemen, the president of which is with us, and she will be speaking one of the tables. Thank you. Thank you very much. Good morning. I'd like to thank you and thank Gloria especially, as she's been very brave to allow us to be present with you here today. Something personal. I'm very happy to be with you because my name in Arabic is Seville. It is my first time in Spain, and this is very exciting for me. First of all, I'd like to say that in general terms, for women judges associations in our countries, we are not encouraged by men mainly. They consider that we shouldn't gather alone. However, I'd like to thank today the president of the appeal court who accepted to come with us to support our efforts. I also like to say that we are an association of women lawyers who work not only for ourselves, we also work with men, and we work for all society. There's no distinction of gender in a job. Another important point is the role of the two Libyan women judges. I'd like to thank them. We've worked very hard so that they could be here. It's not easy for them to travel from Libya to Tunisia. They had to wait some weeks to get a visa and participate in what we do within the IAWJ. Thank you very much for that. We are also with other countries in distress. Another colleague has set up the Association of Women Judges in Yemen. We have begun to work with her. She's coming for the first time to a meeting of the International Association, so thank you for your efforts. We're also very happy to be with you regarding the topic chosen by Gloria for this conference, the gender perspective. As Tunisians, we discovered this in an international conference in Mexico, and there we began to understand how the international system worked on this issue. It is true that Tunisian judges are not. There's a long way for us in this regard. We are working hard on this. That's why I like you to listen to them, because this will be positive for all. To finish, I would like to say what we always say in Tunisia: justice is the base of civilization, and together we will work hard to speak the same language. If we do things separately, we won't speak the same language. The same language is justice, humanity. So thank you very much for being here together to keep moving forward. Thank you very much.
Ahora, sin solución de continuidad, subirán a esta mesa.
And now, let's begin the first roundtable. The speakers, the rapporteur, and the facilitator of the first roundtable, which is the roundtable about criminal law.
Esto es una T, pero bueno. Puedo poner aquí. Bueno. Está mal, pero.
No te preocupes, veo desde aquí.
Sí, batarrita. Basta. Sin acento.
Rita, te ha puesto batarrita. Vas, Ana Clara.
Así no puedo. Sí. No, va a ser pero sí, no te vale, no vale mucho. Bienvenida. Nos hablamos. Sí.
Perdona, esto es a la derecha, a la derecha esto, ¿no?
Sí, eso sí.
Y lo pones por abajo.
Sí, es que Carlos no está.
Ah.
If you want to move here, because Carlos.
Sí. Tengo, perdón.
Lo has hecho muy bien, ¿eh? Lo has hecho muy bien.
Gloria, sí.
Lo has hecho muy bien, ¿eh? Muy bien, muy bien.
Buenos días. Bien, vamos a empezar con la primera mesa redonda.
Let's begin this first roundtable, judging with the gender perspective in the criminal jurisdiction, analysis of gender violence, occupational sexual harassment and sexual crimes. For this, we have the presence of the magistrate, Mr. Vicente Magro Servet from the Supreme Court of Spain, Nadia Stefaniev of the Supreme Court of Ukraine and president of the Ukrainian Women Judge Association, also Magistrate Sofia Karistina Magola from the Supreme Court of Greece, and Magistrate Clara Sotomayor, Constitutional Court of Portugal, Adela Sua Batarrica, Vice President Emeritus of the Constitutional Court of Spain and Professor of Criminal Law, and the Magistrate Fatma Omar El Smalri, who comes from the Supreme Court of Criminal Law in Benghazi, Libya. We are a little bit short of time. Short introduction. If you are interested in getting to know the CV of any one of the speakers, we will send it to you by email. And now I give the floor to Mr. Vicente Magro. He asked me that as he has to go after his presentation, if any of you had any question, once he finishes his presentation, you may address to him any questions before he has to leave. So thank you very much, and I give the floor to Mr. Vicente Magro.
Aquí lo tienes.
Muy bien. Muchas gracias por la presentación.
Thank you very much for this presentation. First of all, thank you, Gloria Poyatas. When she called me to the Supreme Court, she asked me to be present with you today. To me, it is an honor to be in this great Congress on gender perspective. I have here 10 judgments we decided in 2018 and 19. I think they are relevant in the fight against gender-based violence. However, I will begin my 12 minutes. I try to not to go beyond that, speaking about some findings. The first finding I like to put on the table is that we cannot turn victims, women victims of rape, of sexual harassment and gender abuse. They are not the guilty, they are not the accused in this criminal process. Because we may have the impression that these victims are guilty for being abused. The victim is the victim and is never the guilty, and she's never the accused person. So the first judgment, here we have added the notion of gender perspective in the judgment 2047, 8 months ago. So here we introduced the notion gender perspective. It was a case of a murder. The conviction was for homicide. In fact, there was an attempted murder at home by the husband of the victim. All he said to her, the victim said that she wanted to divorce from him. And that's a difficult moment. A woman who had enough to be, because she's been abused, when she tells the husband that she wants to divorce, and the husband, given that possession feeling that he has on the woman, she grabbed her from the hers, took her to the kitchen and stabbed her to death. Luckily, she could escape. After receiving those 8 stabs, she went to the toilet, locked there, called the police, and the police arrived. That happened in the presence of the daughter of 10 years old. There was malice, and we turned this attempted murder into a crime of murder. But here we have to introduce this notion of gender perspective, because there is a malice, domestic malice, gender malice, mainly because of that easiness of committing a crime at home, because the women couldn't escape away. There was an attempted murder and she couldn't escape. That's why we introduce the concept of gender perspective in a fact which is an attempted murder. We also agreed the privation of the parental authority regarding the daughter. She saw how his parent stabbed her mother. This is very difficult to see by a child. Yesterday, a similar case took place in the Canary Islands. A 5-year-old escaped from home when he was witnessing a crime. The judgment arrived without depriving the father from the parental authority, and we said this couldn't be possible. We have to agree to deprive parental authority in these kind of cases. So we agreed this to deprive the father from the parental authority, and we also talk about a very important thing here. We have qualified this kind of facts, talking about the fear scenario of usual abuses, because this victim suffered usual abuses daily. It's a terrifying scenario. On a daily basis, she was subjected to these abuses. And we also point out that she reported this late. If a victim, if it takes 3 or 4 years for her to report, the reason for this is fear. It's understandable, but this may imply a lack of credibility when she reports, and that's not possible. The delay when reporting shouldn't entail a lack of credibility by the victim. If she reports, this cannot be used as a negative support to understand the report of the victim. In addition, there's more risk to be killed when she tells the husband that she wants to divorce. There's a higher risk to see facts as the one we saw. That is why we have to detect risks when there is an abuse report. Forensics, forensic doctors, policemen should detect that risk when a woman reports this kind of abuses. The second judgment, when we also mentioned gender perspective, is from 2018, a similar case, women who separated from the husband, and given that property notion over the woman, the husband took a gun and tried to kill her. These facts should be focused on this gender perspective thing, and that's what we did in this judgment. And there's also a nuance. The value of the statement of the victim, because we said that the abuse victim is not another witness of the criminal process. A witness is not the victim, but we call her also a witness. No, a rape or an abuse victim shouldn't be called a witness. The victim is just that, is the victim of the abuse. So the legislator should change the term, because this is not just a matter of changing the term. This is a matter of reassuring the victim in the criminal process, because she's not a mere witness who saw a crime or an attempted murder. She is the victim of the criminal offense. That's important to put that in a decision. This third judgment is astonishing. 51 stabs to a woman. There was said that there was no persistence. She had to endure 48 stabs until she finally died. Of course, there is persistence in this kind of actions. She separated. He asked her to be forgiven. He goes back home, and 3 days later, he stabs her to death. 51 stabs. So we have to point out the danger of resuming the coexistence when the husband asks her to forgive him and then he kills her. That's why it's important to assess the risk in this kind of cases and alert the victim that the fact that resuming the cohabitation may imply these actions. Judgment of September. Here we also added the gender-based aggravating factor. If you are not mine, you won't be anyone else's. So we added the gender-based aggravating factor here. In other judgments, in this one, we took a step forward because we said that any sexual contact, any fondling is not coaction. That's sexual harassment, sexual abuse. Another important judgment, this one from November, gender-based aggravating factor can also be applied not in a partner relationship. Any attack to a woman just for the sake of being a woman, Istanbul Convention, we can also apply this gender-based aggravating factor. Another important judgment is this one from December 2018, where we saw that we don't have to prove the intention of domination of a man over a woman. Just the fact of hitting or abusing of a man to a woman is already an action of gender violence. This is the proof of the will to dominate over the woman. It's objective that we apply the notion of gender-based violence. Just because of this, the woman shouldn't need to prove the will of domination by the man. This is already a proof of sexism, and we have to add this notion of gender-based aggravating factor. Gender-based aggravating factor in a sexual crime, in a relationship. And this last one from March 2019. Here we took a step forward, coming from 3 terms when assessing the statement of the victim to having, we had 3 criteria, now we have 11. How to assess the victim's statement. Now we have 11 criteria on how judges can assess the victim's statement regarding her credibility in this criminal process. And the most important thing of this judgment are these 6 other criteria. Criteria regarding that when the victim is afraid of making any statement against the attacker, the accused, we should allow the victims to make this statement through a video conference in order for her not to be close to the attacker, so that she can be in another place with a psychologue. And we said victims can be present in the criminal process feeling terror. So these are 6 criteria saying that attention, this may happen. And if this happens, this shouldn't be taken as if the victim was lying. Thank you very much.
Muchísimas gracias, Vicente. Has clavado el tiempo.
Thank you, Vicente. That was great. You were very strict with your time. As we said earlier, the speaker has to leave for personal reasons. If there's anybody in the room that would like to ask a question now, anything for him right now, this is the time. Good morning. Well, first of all, thank you very much for that presentation. I would like to ask if you have ever seen circumstances in which the victim, retracted their words and said that wasn't what happened. Maybe adults or perhaps teenagers who report a family member, maybe their father, stepfather, or somebody who lives in the home. Yes, indeed. The retraction of the declaration is possible, but when that happens, the court can read the statement in the process, unlike when the witness shelters in the 416, and according to that, we are not allowed to read the statement. When we see retraction, this is something we have to evaluate within the context of fear, or also possibly an attempt to protect the abuser. And this doesn't mean that we should believe the report to be false. If she retracts it, a lot of people say that means it was false. No. We need to eliminate that idea, because they may retract their declaration because of fear, regret, this feeling that the victim may have. The fact that their father's going to end up in prison, my children will see their father in prison. So that person is a victim twice. Victim for actually suffering the crime, but also the victim of the psychological consequences. So we could apply the sentence we saw earlier of evaluating the fear of the victim, not wanting to declare. If we take their report from the investigations, this can be used as proof when it comes to seeing this as in use with the declaration of neighbours, the health report and such like. We could use that. Good morning. Thank you for that very valuable contribution. I have worked as a judge in Jordan. I represented the prosecutor's office, and I have seen obstacles for women in cases of abuse, murder or sexual assault. What I saw as the biggest problem was how the judges viewed their testimonial. The women's declaration was also seen with suspicion, in a doubtful way. The idea that this may have been the result of previous problems, and so the credibility of the victim is questioned. Who, in this case, they are also a witness, because they talk to the prosecutor and then they talk in the courts. And it's clear that male judges in the criminal chambers, most of them are male judges, and therefore what we observe is that they always question the testimony of the abused woman. And when I represented the prosecutor in my work, I always asked, why does that happen? Why do they always question the credibility of the women? You spoke about the fact that there are criteria according to which we should, or upon which we should base our judgments with a gender perspective or not in the commission of a crime. What are the criteria to be taken into account when it comes to evaluating whether we have a case of gender-based violence or not? And the second question would be, if we find that there is gender-based violence, could we apply aggravating factors? Because, of course, as a judge, I cannot apply aggravating factors without that being established in the law, without that being a statutory element. So how could we apply those aggravating factors, and then how could we use them in that case? Thank you for that question. I don't have time to talk about the 11 criteria. It wasn't just one criteria, it was 11 criteria. In the past, we had 3 criteria in Spain for the evaluation of the declaration of a gender victim, and we understood that we needed to increase the number of criteria. criteria to 11. So we increased it by 8. This is the body language. What's the difference been between the investigation and what's said in the oral hearing? These are perspectives. The translator, the interpreter, the Arab or the English, I'm not sure. Can you hear? Yes? Can you hear? Okay. We have gone from having 3 to 11 criteria. 11 criteria because we understood that we needed to increase our perspective in order to study what the victim was saying. What did they say in the investigation? What did they say to the police? What did they say on the day of the trial? How they express themselves with their body language, the body language during the oral hearing, if there's contradiction between what the prosecutor and the prosecutor says and what the defense counsel says. If there's fear in the answering, whether they answer all. So these criteria, but for me, the most important criteria are the criteria based on fear. I become silent, I answer briefly, short answers, I'm fearful, I start to cry, I want to leave. We have said that it's understandable for that to happen because the victim is frightened being there. They have declared probably 3 or 4 times to the police the first time with the investigating judge. Then the court judge, if it was suspended for whatever reason, she has to go back to the court. And so she could be there 4 times. The victim is really tired of having to talk about the 5 or 6 or 7 years of suffering. When the victim is already tired when they reach the oral hearing, which is the most important day, we mustn't think that that tiredness, that fear is anything except for the fact that that they are tired of the system, of us. We wear the victims out by making them tell their story over and over again. And those repetitions can lead to contradictions. And the defense could say, well, first of all, she said this and then she said that. But she's tired. She doesn't know what she's saying anymore. So this whole context, we have to take that into account. We shouldn't take that, we should know that we have to understand that the victim is tired of her abuser and of us in the legal system. That's something we have to take into account. And then the gender-based aggravating factor. We have introduced a 20-4, which is an aggravating factor for crimes that do not already have the gender factor. I mean, if we're talking about the domestic violence, if it's already included, but if we have rape or a sex crime, if it's involving domination, we apply aggravating factor, and we use the Spanish law, which allows the judge to increase the sentence when there is a sexist factor, a gender-based factor. And not only can we apply that in intimate relationships, but in any attacks against a woman due to the fact that she is a woman, even though it's not a partner or an ex-partner. So we can have the gender-based aggravating factor, even if the relationship between the attacker and the victim is not one of having an intimate relationship, but just because of the fact that she is a woman. Yes, the next one. Yes, please go ahead. Good morning. With regards to the subject of the delay in reporting due to fear and such like, I would like to ask about women in specific cultural groups. There seem to be some women in China, for example, or Muslim women, Gypsy women. Due to family issues, they try to resolve issues in the family and take a long time to report. This is related to a study I'm doing for Oxford University. I'm finding information, and a duty lawyer in Madrid told me that there was a case just like that. It was a woman, a gypsy or a woman, who reported something very late. And so this perhaps links up with what you mentioned, this delay, and the fact that this should not be taken to reduce their credibility. But if we talk about legal times and you're talking about the expiry of the crime, well, we can't do anything about that. if it's for something which has extinguished, unless we change the time period for extinguishment of that particular crime, we can't do anything. I mean, that's nothing we can do. That's up to the legislator. If the legislator wants to increase this statute of limitations, then that's the only possibility. But if there is a specific date of the crime and then the date for the statute of limitations, then there's nothing we can do about that if it falls outside that limit. Okay, very quick, please. I'm Beatriz Miranda. I'm very grateful to have a chance. I don't want to miss this opportunity. You talked about the 11 criteria that we have to take into account when it comes to looking at the credibility of the victim. I work in a criminal court, and I often find that it is difficult to evaluate statements or testaments because they are the people, the witnesses are really being led, let's say. So I would like to know your opinion about this point, because in the criminal courts, well, judges in these courts, we have to evaluate their declarations, and short answers do not help us. What can we do? Yes, that's a good question. Yes, that's why we have 6 negative criteria, because we could refer to the 6 negative criteria with regards to what you're talking about. So how do we evaluate their testimony? When we see them inhibited, fearful, wanting to leave, they just want to get this out of the way, let's say. So they give short answers because they want to leave. They don't want to see us. And what's more, it almost seems that they don't care what happens. They just want to report, I'm here because they're forcing me to come here, but I don't want to. And maybe I don't even want them to sentence the abuser. I would avoid this when we have a jury. When we have a jury, I've always thought that, well, if I, as the chair of the jury, ask a lot, then if the judge asks a lot of things, then the jury is going to think that the judge has a specific idea of guilt or innocence. But if we're talking about a professional panel, you can ask questions without having to worry about what the jury thinks. So you can ask questions. You can say, please, could we have further information? Why did you say this? Why did you say this in the police station? I can interrogate them as a judge. That doesn't mean that we are contaminating or carrying out a kind of inquisition. No, it means we want to find out the truth about what has happened. And they should not accuse us about, being impartial or to really create an inquisitional context. No, we want to find out more information. It's not that we're looking for information in order to convict. No, it's just that we want more information in order to find the truth. I'm sorry, we have 5 other speakers, and we only have until 11:30, so we can't have any further questions. I'm very sorry. So we will continue. We'll continue, as I said. We'll give the floor to Nadia Stefanev from the Supreme Court of Ukraine, and the chair of the Association of Women Judges in Ukraine.
I'm very glad to be here. I'm very glad to participate in this international wonderful forum. And thank you, Gloria, for invitation for me. Microphone. Sorry. I'm Nadia Stefanev. I'm from Ukraine. Some years ago, in Ukraine, some judges adopt the National Association of Women Judges in Ukraine, and our association is very young, but I think that will be some experience, and my participants in this forum is really useful experience. Now in my speech, I'll tell you about the new legislation in Ukraine, criminal legislation, because I am judge of the Criminal Cassation Court. In Ukraine, only 2019 years, from January 11, we have a new legislation, the change about domestic violence and gender-based violence. There are many cases of domestic violence in Ukraine. Every day in police, to police called many women and tell about violence against them. And we have a new article in criminal code, the article sexual harassment and forcing to marry, domestic violence, special article, and paragraph 10, the article 115. This is the murder combined with rape or sexual abuse. And in the new legislation, the change article rape, and now changed not only the definition but also the proof of the crime itself. If earlier it was necessary to prove the use of force the victim, now point of reference is the consent of the person. I think that this position, the same is the Istanbul Convention, but in Ukraine, Ukraine signed the Istanbul Convention, but not ratified it. And the new legislation means some ratified some point of Istanbul Convention. In new legislation, we have a new definition of the domestic violence, the physical, psychological, economic violence against a present or former spouse or other person with whom the perpetrator is or was in family. Early in Ukrainian legislation, we have article only is in family. Yes, thank you. And okay, challenges. We can see we introduce new concepts: offender, child abuse, and child affected by domestic violence. This is a specific subject. We start the Unified State Register of Domestic Violence and Gender-Based Violence I think that this year we have some cases and the register to start. And the police can to take organ prohibition order, and in the civil court, the judges in the civil cases to take the temporary restraining order. The temporary restraining order is longer. I think that's 6 months, but organ prohibition order only 10 days. And punishment in the Criminal Code of Ukraine is strengthening, and now we have not many cases because it's a new legislation. And in this period, these cases are in a police in the investigator. But in this year, we development of implementation of training course for judges, for prosecutors, for psychologists, and for police, and the representative NGO. And I think that it will be useful because each member to see in one way, and understanding the new legislation the same. In Ukraine, we have the National School of Judges and National Association of Women Judges with cooperation is National School of Judges to developed and implemented the specific training course for judges, the cases cases of domestic violence, peculiarities of the considering. Now, 25 trainer judges representing all regional divisions of the Ukraine were prepared during the training for trainer. They are trainer for judges and the trainer for prosecutors and police. Next slide. There's some problem of gender-based violence in Ukraine, and I think it's a problem of each country. But I see that in Spain, Spain had a good experience to protect the victim of the basic gender-basic violence, of the victim domestic violence, and I think that Ukrainian here in the first step and the knowledge of international standard and the practical cases and the understanding the gender equality's use will be useful for judges of Ukraine and will and we can to protect the victim of the cases of domestic violence. Some words about Ukrainian Association of Women Judges. Our association includes many judges, the Supreme Court, the Court of Appeals, the District Court, and in the Supreme Court we have a President Supreme Court's the woman, Pani Valentina Danishevska, and I must to express for you, yes, and greeting for you for this forum. And I think that maybe next forum we can organize it in Ukraine.
Oh, thank you very much. Thank you very much.
Thank you.
Muchísimas gracias, señora Nadia Stefani.
Thank you, Nadia Stefani. Now I give the floor to Magistrate Sofia Calistino Magola from the Supreme Court of Greece.
Gracias.
Thank you.
Okay, I want also to thank you very much for the invitation. It is a conference very well organized, but the International Association and the Spanish Association is famous for organizing good conferences. So I will try to be very, very short because we are a little out of time. But it's due to that we began very late. Anyway, I will try to give you some very idea of how our laws are and how the jurisprudence in Greece is. Greece is one of the members of the European Union for many years, so we are lucky that we are in West country, and we have already established gender equalities many years ago, but that doesn't mean that we establish it, that we also apply it. It's another matter. Anyway, I am in the Supreme Court, and we are both penal and civil judges together. After some years, we become one or the other. So I want to give you first this one. Okay. Very quickly, the quality based on the Greek Constitution that men and women have equal rights. But there is also another article that says that there is no gender discrimination if you take positive measures for the women between men and women, and the state will ensure the elimination of inequalities and exist in practice, particularly against women. We have, this is in domains, I give you example, employment, reconciliation of professional and family life. That is the harmonization with the European Parliament and the Council, the directive. And the law, this law concerns, among others, the following: the principle of equal treatment, protection of rights in compensation or reparation for losing a job, that it's very common to countries that have crisis as we are, maternity benefits, promoting substantive gender equality, prevention and combating gender-based violence. Violence against women, criminal laws, legislation regarding issues of preventing and combating violence against women, ratification of the Istanbul Convention. We did it. We did it. I was a member of the ratification committee. And combating domestic violence. Human trafficking, we in Greece have a very, very severe problem for human trafficking. This is in combination with the refugees we have in thousands in our country. So there is ratification of the Warsaw Convention, prevention of and combating human trafficking and protecting victims of this and other provisions. You will see examples later. Two articles for the residence and social integration of third country nationals in the Greek territory. We have too many. Among others, there are provisions for the victim of trafficking to issue a residence permission, as well as to not to be deported. It's interesting to keep the victims in the country so that we can present to a court later and tell us what happened to them. Amendments to center provisions of the Penal Code, Criminal Procedure Code, and to the Civil Procedure Code, as well as certain other laws. Social Security and Family Law, Social Security beneficial provisions for divorced people without income to receive retirement pensions after spouse's death. So maybe you are divorced, but you take the pension of your ex-husband because you are poor. Family law, full compliance with the European legislation, adoption of all directives, all European and international conventions. This is an achievement many years ago, participation of women in decision-making centers. Establishment of a gender quota for the balanced participation of men and women in service, boards, and other collective bodies of administration. It ensures that the balanced participation of men and women in decision-making, and especially at least 1/3 participation of women in the departmental boards and collective bodies of the government, public institutions, and local authorities. Also, there is a quota of 1/3 in the electoral lists of prefectural and municipal elections. Healthcare and family protection, there are benefits for women that they have no means, rules and equal rights to unmarried women. In implementing all the above rules, it doesn't matter if you are married or not, but you are a family. And now now we have the application to a couple. That means that no matter what the gender is, if there is a couple and there is a family, they have all the protection they need to have. Equal access to goods and services and equality in the workplace. This is also something very interesting, the workplace. So we had adoption of all directives. So before entering the jurisprudence, I want to tell you something. We have all these laws, but the Parliament has a majority. All these laws can be changed very easily. If you have the majority in the Parliament, you can change all this protection and all these laws. As now we are all watching, recently there is an uprising wave of political parties of extreme, and they have in their program openly intentions and declarations that they will change all the analyzed below laws. They say no equal rights to women, a very clear gender discrimination. Even the attack to the LGBT community, to the refugees, to the foreign people in the country, in all countries. I think that this is a phenomenon now in Europe, and it spreads all along. So, in some countries, I don't want to name it, they changed recently the law of judges so that they can change the limit of age and to deport, not to have the judges they want. President of Supreme Courts, vice presidents of Supreme Courts, and judges. So they changed suddenly the law so that they don't have the judges that protect their people. So we have to have an open mind, and please keep alert and have in mind to do your job as honestly as you can. Now we come to the jurisprudence. A high number of decisions of courts of all degrees, the Supreme Court and the State Council, apply the basic principles of equality in civil, in penal, and administrative cases. I have used some examples that they are the opposite, that they say it's against the community law and gender equality not to provide parental leave to the husband whose wife is not working. So husbands may ask the parental working for raising their children. Smaller than usual retirement age established for women in the past should be extended to the men if they work under the same conditions. Domestic violence. Many decisions of the Supreme Court for the domestic violence, the family member practicing verbal abuse or using physical violence or using threats must be punished by imprisonment. Sexual harassment. Many decisions for sexual harassment against minors or on the work floor, because we have sexual harassment on the work floor. Also, trafficking. This is important. It's a criminal organization persuaded young women taking advantage of their vulnerability due to lack of money, the imperative need of work, and their unfavorable economic situation, coupled with their illegal stay in the country, to work as private dancers or client escorts, often offering sexual practices in a specially designated area of the establishment for the amount of 10 euros for each simple dance or 30 euros for sexual practice. This is women trafficking, but we also have trafficking in order to commit thefts from Bulgaria, minors, women or disabled people forced to commit thefts, trafficking of people illegally entering the borders by the sea or by the frontiers, taking advantage of their vulnerable situation as immigrants. We have a severe problem in Greece. The above is now the most common crime of human trafficking with thousands of people. Conclusion. Despite of this legislation, I give you a summary of this. Greece is the last country in the European Union in applying the laws and the jurisprudence. What? Because the United Nations experts who were in Greece the last week told us that it's a poor implementation, the continued discrimination and prolonged impact of the crisis and austerity measures. That it means that if you don't have economic means, you cannot protect your people. So the crisis is not only economic crisis, it's crisis of civilization, it's crisis of the quality. And things, I think, are getting better, but we are all must try. From our positions as judges or prosecutors, we have to try to keep improving the situation and pursuing our goal to give equal chances to all human beings, despite gender, age, or origin. This is what we took an oath to serve and preserve when we became judges. After 40 years of serving justice, I assure you that it is not easy. It requires effort, persistence, and a lot of work, but the moral reward makes the effort worthwhile, be sure. Thank you very much for your attention.
Thank you, Sofía. En estos momentos pasamos.
Now I give the floor to Magistrate Clara Sotomayor from the Constitutional Court in Portugal.
¿Puedo hablar con esto? No es
Sí,
necesario.
por favor, es que si no...
Sí, gracias. Buenos días a todos y a todas.
Good morning to you all. Greetings to all the magistrates, judges, to the audience. I'll try to speak in Spanish.
Quiero agradecer la invitación para estar aquí presente.
Thank you for inviting me, Gloria. And thank you to the members of the Spanish Association of Women Judges and the IAWJ. It's a pleasure for me to participate to talk about sexual crimes in Portugal. Gender-based violence in all its ways are epidemic phenomenon in all societies. We see this with black digits. This means that many women who suffered this violence didn't report this. The tradition is to keep silent. This is changing. slowly, because all sexual crimes against children in Portugal are public crimes. What does this mean? That the prosecutor's office can bring that case to justice whether the victim wants it or not. But crimes against women are not public crimes. For that we need the cooperation, the active participation of the victim. The concept of gender-based violence in the Portuguese law does not appear directly, but by virtue of international conventions ratified by our state, this has improved our legal system. Violence against women has a structural and historic nature, an ideological and political meaning. It's a mechanism to subordinate women. Fighting against gender-based violence means that we are contributing to build a society where men and women are equal. Since Portugal ratified the Istanbul Convention, we have introduced in a criminal law new crimes. We introduced new crimes like forced marriages and female genital mutilation, amongst others. Sexual harassment, foreseen in the Article 40 in the Istanbul Convention, is an undesired behavior of sexual nature on verbal, non-verbal or physical form as a try to violate the dignity of a person or to create an environment which is intimidating, hostile, humiliating or offensive. This is a concept which in Portugal is foreseen as a very serious violation in the labor code. So legislation complies with the Istanbul Convention. But many other crimes are related to sexual rape or other kinds of abuse. Sexual harassment 38% of women in the EU, the European Union, suffered sexual harassment throughout their lives. 38%, as I said, between 18 and 39 years old, were victims of sexual harassment in the last 12 years. The concept of harassment in this regard is a larger concept than the one foreseen in the criminal code. Even offensive remarks about the physical appearance of women in an intimidatory way, exhibiting pornographic material and fondling. Women at work are those who suffer. Women at work who suffer sexual harassment are those, mainly are those who have senior position, responsibility positions. This causes very serious psychological damages to the victims, which may lead victims to try to kill themselves, because our workplaces where we spend most of time, and they need the money to raise a family. All sexual crimes cause important damages to the victims, and we have to ponderate that when taking judicial or administrative decisions regarding victims, and also when implementing protection measures for the victims during the criminal procedure. Sexual crimes cause damages to the confidence of the victim. If the attacker is a member of the family, or if he works with her, women may lose their autonomy. Post-traumatic stress, an alteration of the biopsychosocial balance. In the case of children abused by the father, this implies the dissociation of personality, anger, fear, depression, anxiety, loss of self-confidence. So all there are reports of forensic medicine that normally talk more about moral damages. In the justice, we normally tend to focus only on physical damages, but moral damages are also very important. When assessing a sexual crime, when judging a sexual crime, in all these modalities, ranging from rape to verbal sexual harassment, what's at stake is victims' human rights, women's human rights. They are the victims. We have to protect all the rights of women when they suffer any discrimination or violence, but the trend in the social and legal discourse is not to tackle threats that don't turn into specific physical actions. They are normally ignored, these actions, but the behavior of the offender causes damages in the victims and in the society. So here, the state and the society should fight against sexual harassment, even in the less serious actions, because the structural character of this harassment, since the very moment of a children is abused, this implies that women don't participate so much in the public discourse. So this is negative for the whole society and not only for the abused woman. Let's don't forget that mainly most of women throughout their life suffer an abuse. So society, at the end of the day, sees this as a natural thing. And now, talking about more serious crimes, rape, for instance, the notion of these crimes are changing. They were amended in 2015, but the amendment was considered not to be enough to protect the victims. Rape crimes needed to bring that to court, needed to have evidences of non-consensual sex. What happened back then is that most of these crimes were not punished, not even reported. to the criminal system. This a very famous case in Portugal that gave a lot to think to the society. A pregnant woman was raped by her doctor. The district court convicted the doctor to 5 years of imprisonment, but a higher court changed that decision, understanding that unconsented sex is not a crime. So the raper was acquitted, saying that the victim, although she was pregnant, didn't resist. There was a huge public debate that led to the amendment of the law. But with that, the amendment was not enough, because now, in 2018, the law was amended again, reiterating the need of physical violence or serious threat, but the victim still has to be forced. For instance, if a woman has drunk in a disco and was fainted, was raped by 2 men working in that disco, in the toilets. So the court convicted those 2 men because for abusing that woman, but the conviction was not because of the rape. So there was a huge debate in the Portuguese society, and we are again trying to amend the law. But let's make no mistake, the law is not the main thing here. The main thing here, the key, is the mindset, this sexist mindset we have in our country. Thank you very much.
Gracias, Clara. Concedemos la palabra en este momento a la señora Adela Suabatarrita, vicepresidenta emérita del Tribunal Constitucional de España y catedrática de Derecho Penal. Por favor, el micrófono, ¿cuál te va mejor? ¿Cuál?
We have a professor in criminal law and emeritus deputy chair of the Constitutional Court, Adela Suabatarrita. It's a pleasure to be here. It's a pleasure to share this panel with these colleagues from different countries and to share our concerns that we feel in each different country. And now, in the second decade of the 21st century, at the end of the second decade, we are reaping the rewards of international efforts that have begun, above all, since 1979 with the Convention for the Elimination of Discrimination Against Women. Well, since then, we have all collaborated, all countries have collaborated in forging a path based on collaborating and focusing on social problems, and above all, problems which affect women, because women suffer violence and discrimination. But this also affects balance and peace, so has a wider impact on the whole of society. It's a pleasure to see that indeed in all countries efforts are being made to bring about this change. I would follow on from the words of our colleague from Portugal, because indeed this is all about our perspective, our mindset, our outlook, which must be accompanied by laws and, of course, the interpretation of the laws. And that's what we are working on. But we have to all work in the same direction. If we talk about gender-based perspective, that involves being aware of the fact that we are talking about recognizing our own bias and in understanding behavior and how the gender perspective is what helps to ensure that the seriousness of discriminatory behavior is understood. I mean, this kind of behavior has existed for centuries, but only now are we beginning to understand or see them as harmful behavior, because for many centuries and even until just a few decades ago, this behavior was hidden or tolerated. The gender perspective means that we recognize the fact that we have inherited cultural patterns and structures in our conception of the world based on a certain assignation of roles, the subordination of women in relation to men. So we are now moving with our international declarations and our constitutions, we are moving towards a change brought about by this new understanding. And this is huge. We are changing our view of expectations and roles in the world of care and in the world of public responsibility. This change is so important. It began some time ago, but it really revolutionizes everything. And sometimes, although we may stumble and we may make errors in our progress, it's important to bear all of this in mind, because we are trying to use a different language, the language of human rights. Since 1948, Article 1 of that Declaration of Human Rights that states the equal dignity of all men and women, that's when we see the first development of the consequences of that right to equal dignity. And that is what is behind the change. This was a slow change, but above all, it's a change in mindset, because we've seen that violent behavior against women, exclusion of women, the patterns are the same throughout the world. In some countries, we could say they're less prevalent. Okay, but some examples that we have seen this morning, the murder or the attack and sexual harassment, sexual assault, they occur in all countries. And this is because that established order that we want to change has been practically the same all around the world. Following the Declaration of Equality, if we use the same language to talk about women and the changes in the distribution of opportunities and the denial of opportunities to women and what that demands, or what that involves, and now the demand for joint involvement of men and women, this is so vast that we are needing to change our outlook, to change our glasses, let's say. So let's hope that future generations will see things differently, although they will face other obstacles and other difficulties. So this shift in paradigm will have its impact, obviously, in the law. And as was said at the start, it's important to judge with impartiality, but also with recognition and an understanding of the reality which was not viewed in the same way in the past. So now we must approach things always taking into account the importance of the equality of people, now based on tolerance and the acceptance. In the past, women had to accept and tolerate certain things in order to maintain peace in the family, in their role of self-denial and the denial of their rights, this self-sacrifice. This recognition of our perception of our roles as women and men that we have inherited, at least the older people in the room would understand what I'm saying more easily, has meant that if we want to progress, the criminal and non-criminal laws, although we're talking about criminal law right now, have begun to establish abuse as things that in the past were just considered to be troublesome behaviors, and which in fact could lead to acquittals, because sometimes even through till 1980 something, and through till 89 in Spain, there was no recognition of abuse, physical abuse of women, as something which was not just a private issue. Sexual harassment at work, sexual harassment in the home, and now cyberbullying or cyber harassment. These are recognized now as something which is harmful for a society based on equality. These things, however, were considered private issues and were tolerated in the past. International conventions that affected all countries that signed them explain that the agenda is becoming unified for everyone. And the gender perspective needs, first of all, to change mindsets, in some cases to change laws, and, well, we've heard examples about this. We've heard about abuse and harassment from Magro Servet. We're not just talking about changes in law, but in the changes in mindset and in interpretation of the law when it comes to sex crimes. That change in mindset that is related to the interpretation of our laws is what explains why in Spain in 1994, 25 years ago, the Supreme Court stated that aggravating factors for the murder of a spouse, usually the wife, made no sense because aggravating factors responded to a failing or a betrayal of loyalty. But this changed when there was no longer an affectionate relationship. So in those cases, when there was no longer an affectionate relationship, it didn't need to be considered as an aggravating factor. It was just like any other kind of homicide. 2019, the Supreme Court, and in 2018, the court recognized that the murder of a wife should be take into account the aggravating factor of the gender criteria. The aggravating gender factor was modified when talking about ex-wives or ex-partners. The meaning of the death of the partner or ex-partner has taken on a different dimension than that which existed in the 1990s. So things have changed. We are changing our expectations. The same thing has happened with sex crimes. I would like to give an example of the paradigm shift here. The sex crimes from this perspective is they talk about the honor, a woman's honor. So it was an attack against their honor, and traditionally, and in many countries, we still see this in many countries, and even here in Spain, there were two figures. We had sex crimes. To just summarize this, it talked about rape, which is a crime that requires intimidation or violence in order to overcome the woman's resistance. The honest, honorable woman So when we think about rape, our unconscious mind comes up with this idea that the woman, well, this corresponds to the old regime of differences and unequal roles, subordination and domination. The woman, as the maximum value, is their faithfulness to the man, their honor. So in Spain, people used to say, better dead than raped. The worst dishonor for a woman was to be raped. So the idea was that the woman would necessarily resist. On the other hand, we had sexual abuse, which was a minor issue. Obviously, we have changed, but that dichotomy remains in the collective imagination and in legal interpretation in many cases. It is now beginning to change, but this is what explains the case in Portugal of the rape of the pregnant woman. They said, well, that's not rape. And in Spain, the case of a group of young men at the San Fermin fiestas, the five of them attacked a woman, and this woman allows them to do certain things. We've had the same problem. They were convicted, not for rape, but for abuse, because there was not sufficient resistance. This takes us to the issue of an interpretation of intimidation. It takes us to the issue of why intimidation and violence was considered a serious offence compared to lesser offences which did not involve violence or intimidation. So our understanding of what sexual offences represent lead us to consider the fact that, well, the code was changed in Spain more or less in 1990, 1995. If in the 90s we already said that sexual crimes represent an attack against the freedom of a woman, because we understand that a woman has free choice and decision over her sexual relationships. Well, I just would like to say that with freedom, well, our interpretation and our legal codes need to change, because the description and interpretation should not refer to the desires of the individual, but rather the desire to attack the freedom of the woman. And if the woman has not given their consent, we are talking about a crime against sexual freedom, and that's what should prevail in our interpretation of the law. And to do that, we need reform. The criminal laws will not change everything, but we need to work in line with the investigation that it tells us what is harmful, and in line with sensitivity regarding the importance of what is an attack against the freedom of women. Thank you.
Gracias, Adela. Y concedemos ya la última palabra.
Thank you very much. We shall give the floor to Fatma Omar El Masri from Libya. Thank you very much. You have the floor. First of all, I would like to thank all of the participants and also the International Association that has organized this meeting, this conference. We hope that you are aware of the situation in my country, because my country is suffering very difficult situation right now. Having said that, many of you maybe are not aware what's going on in my country, and many of our Arab sisters do not know anything about the story of women judges in Libya. They don't even know if there are any women judges in Libya. Libya modified the judiciary law in 1989. Since then, we have seen women judges in Libya. Women have been appointed and have been promoted to judge right up through to the Supreme Appeal Court. women judges in Libya represent 80% of the total. That's not a problem in itself, but the problem is that although women may be promoted, nonetheless, there is always a superior who is a man. That's the first thing. Secondly, the General Council, well, only recently we saw the arrival of a woman to the Supreme Court General Council. The only case was in Benghazi because most women judges in that Supreme Court in Benghazi, most of them were women, so there was no choice other than to appoint a woman chair. This percentage, however, is very low. In Libya, women have not demanded those rights. They were granted by the political regime, and now what we have is a situation in which those rights are being withdrawn and taken away again. We have the situation of Libya that we're all familiar with, this warlike situation and this conflict. There are lawyers and male judges who have alleged the inconstitutionality of women working as judges. They wanted to, make it impossible for women to work in the courts. They alleged that in the courts, all of the positions should be given, or all the cases should be given to male lawyers and not to female lawyers. As from 2011 through till today, Libya is in a very difficult situation. All of the institutions, organizations, and civil society has collapsed, and that obviously has had an impact on the status of women. There are no discriminatory laws. All the laws refer to men and women. However, there are some laws, some articles, some provisions do clearly discriminate against women. For example, there is a law from the 1950s. It's an obsolete law, and, well, as you know, in Libya, there is a tribal tradition, so we have tribal laws which are sometimes stronger than the other ones. So we have a case, for example, if a man goes into the home and finds someone from outside the family, a person, a stranger, in their home, they can kill that person with no issue afterwards. But if a woman finds a man with their husband with another woman, they have no right to kill her. So, and even in the universities, the professors taught us that. The professors teach their students that in our universities. What we want to highlight here is that women in Libya are fighting to change the situation and also to occupy positions of responsibility. All working women in Libya have the same rights as men. They have university, academic training, and they even work more than men, and that's something that is recognized within society. However, the problem lies with rules and tribal laws that are an obstacle to women. Recently, a decision was taken to prevent women from traveling without the approval of their husband. or their guardian. So a doctor or a female judge or female engineer cannot travel without the consent of their family or their guardian. And this, of course, was rejected by many women, and they have criticized this decision, and thankfully, as a result, it was annulled, it was cancelled. If we talk about gender-based violence and sexual harassment, sex crimes, in Libya, it is felt that this is not a serious issue because we have a very conservative society still, and it's governed by tribal customs, which are very strict. Nonetheless, following on from what happened in 2011 and the changes which have occurred, we have heard about many rapes, above all in the militia, in the prisons. Many women who were abused, tortured, they suffered sexual harassment, some suffered rape, with sticks being used to abuse them. And this was put on the social media. But this is what's happening, the things that are happening in the prisons. Other women had to leave as refugees, ask for exile, and went into exile or asked for asylum. Some women were forced to become prostitutes in order to, feed themselves. The war lasted 4 years, almost 4 years, and now the conflict continues in the western part of Tripoli. The situation in Libya is very serious for women, for minors. It's a tragic situation. If we not to mention the humanitarian problem, it's really serious. The United Nations and international organizations, NGOs, go into Libya, but now we're talking about issues such as displacement of huge number of women. But these organizations have still not gone into the prisons, those prisons where there are no female staff. It's all male staff, and they abuse the female prisoners. I hope that in the future this situation will change. We are working to achieve that, and we are convinced that with the goodwill of God and the protectors of humanity and peace, people will take action to help us to rebuild our country. And in terms of justice, the judicial power in Libya, I would just like to say that our judiciary system is famous for being independent and honest, despite the fact that the work of the courts has been paralyzed and stopped on many occasions, just as the work of the institutions has been stopped at times of war and the barbarities committed by the militia. Thank you to you all. Thank you for inviting me, and I hope that these days, this conference is of great use to all of us. Thank you very much.